Hey everybody, it's Matthew, and yes, it is that time of year again. It is coming up on July 1st, which means a list of new regulations that impact real estate. And so we're going to jump into the things that I think are most practical for what you and I do every day. All right, so as I said, there are going to be some regulatory changes that I've decided not to do in this update because primarily this is going to be residential or commercial agents listening to this. There is a list of VRLTA or Virginia Landlord Tenant Act changes that have occurred. For the most part, most of these are only going to involve relationships between landlords and tenants after lease acceptance and ratification, not really in the application packet. And since most of you watching this likely don't do a lot with property management or landlords and tenants after the fact, I'm omitting that from here, but for those in property management, you will have an update through VAR soon, specific to you and how these things apply. And then also I'll add a link to this video of a list of the regulatory changes. So the next change that exists was a group of changes were a number of broker-related things. One of those I'll just touch on and save you all the headache of it. If there is, actually just say in an effort, and this was a Governor Youngkin initiative, they wanted to make getting licensed in the Commonwealth for all the different businesses easier. So you've probably read about this. We've done, I've mentioned this in the past in other meetings. And essentially what he's trying to do is to lower some of the headache, if you will, and I'm paraphrasing talking points. I have no idea what his real initiative was. For people who want to come into Virginia to work, maybe that have contractor license or skilled labor licenses elsewhere, including real estate, to make it a little easier. And so reciprocity has been better defined. There may be some waiving of classroom time and some other things just to streamline the process. There's a list, and unless you're with this on this video and you're in DC and Maryland and thinking about getting licensed in Virginia, it probably doesn't apply. You just need to know there are some easier steps now to getting a license, and it's every license under D4, not just real estate. It was part of this legislative package that takes effect on January 1st. And then another group is some regulations that really only apply to brokers about hiring practices and what can and can't be in a non-disclosure agreement if there's a conflict, what you can and can't use social security numbers for, things like that. Doesn't really apply to independent contractors or agents, but if you're reading updates, you may see I omitted some of those things just because they weren't relevant to the majority of you. So with that said, what we do think is relevant, number one, is a change in how unrepresented sellers could be treated in future litigation. And so we as real estate agents are already exempt from the Virginia Consumer Protection Act as agents because we have this whole other set of disclosure rules and penalties if we misbehave aside from that. Apparently there was some confusion about whether or not a unrepresented seller, or the colloquialism we use is FSBO, if a FSBO had any obligations to the Virginia Consumer Protection Act. Now, the VCPA is generally required for businesses who do business with consumers, so business to consumer type models. And the practical part of this is if I am representing the buyer and there's an unrepresented seller, I should probably let that buyer know, hey, they're exempt from the Consumer Protection Act. This is even more reason for us to do all the inspections and things because it's even, not that the seller had any obligation to make disclosures before, but now the standard is even different for them. If they were subject to the Virginia Consumer Protection Act, an example of what the buyer would have enjoyed is if they found that the seller misled them, did something unlawful, they could sue for 3 times the damages in a punitive damage lawsuit and get their attorney fees. Well, because the unrepresented seller is exempt, it would be a standard suit for damages only, not your punitive 3 times, maybe or maybe not attorney fees, those type of things. So there is an impact to the buyer. It is not a significant one. It is just one more thing to remind that buyer that the seller has a very low threshold for liability, absent of a civil suit for misrepresenting the home. All right, next. Then this is the much bigger change, is the resale packet. So what happened with this legislative cycle is that they combined the condo docs and they combined the property owner association into one law, which is easier for you and I. We won't have a condo doc and a POA doc section in our contracts anymore. The timelines are the same. They've been merged and combined. The contents of what we now call the resale packet, forever this has been called the disclosure packet, with the new legislation and the combined regulations, it is the resale packet. We'll still be calling it disclosure packets for 10 years now. But that document now has about 30 elements that have to be in there to constitute full delivery. Some of those elements are new and didn't exist before. I'm not going to go in this video through the 30 of them. If you're a super nerd like I am, you can read them. And again, I'll give you a link to where you can find the actual regulations that outline them. We will have some cheat sheets come out eventually. It's on my list to do, of saying, hey, here's your, just make sure to get a complete packet. These are the things the regulation require. Just in case there's a challenge as to whether the packet was delivered. Now, so a couple of things. Again, easier for us. There's now one reg instead of two separate regs with deadlines and all the rest. Number two, easy, is that they've also specifically stipulated in the regulation that days for termination are now calendar days. Now, it's always been calendar days. It just wasn't as explicit in the regulation. And to clarify confusion and conflict that have been existing before about whether it's business or calendar days, it is now just simply calendar days. Remember that a few years back, we changed the 3-year right to terminate, or 3-day rather, right to terminate, to 3-day right to terminate unless buyer and seller agree to extend it up to 7 days. Now, follow this because this is important. The regulations that have changed still require, no matter what, a delivery of the resale packet to the purchaser. Right? That's important. They have to deliver the packet. That is not waivable in the regulations. That is an obligation. However, there is some suggestion out there and then some lack of clarity. So I'm assuming the suggestion is probably on the accurate side, but I don't know that for sure, that it was an omission, that the committees who worked on this and those who voted for this missed the fact that in this new regulation, a very important line was omitted from the regulation, and that is a line that says the termination right of the buyer is unwaivable by agreement. And remember, all the way up until now, July 1st, the buyer has not been able to waive their right to terminate. So if you're in a multiple offer situation and the buyer is looking for anything they can do to be prettier to the seller and get their offer accepted, they were not able to waive their right to terminate. They cannot waive their right to receive the packet, but now, because of this missing part of it, they are able to waive and say, yes, I still get the packet, I get that, but I am not going to make you fix anything. I will inherit all the challenges here because I don't enjoy the right to terminate based on what I found in there. Now, again, follow this. Our contracts, however, say that the seller is obligated to mediate anything that may make it not insurable. Because HOAs have the right to put liens on a property and demand things of sellers, if the seller does not resolve a repair, the contract will still afford the buyer the right to terminate or hold the buyer, or the seller rather, in default. What is missing here now is the buyer doesn't have the unilateral right to simply terminate. The next pretty significant change is kind of a change back to where we used to be. There was some negotiation between property owner associations and the regulators when they were trying to make all these changes and make this stuff a little easier for consumers. And if you recall, many years ago, the homeowners association or property owner association or condo had the right to charge you at the time the packet was to be delivered, or they would hold it until you paid. And then we changed the law to say, well, in professionally managed POAs, they could defer payment of the packet until closing. So the seller didn't have to pay for it at the time of ordering, they could defer it. We are back now to the packet can be, the property owner association or the condo can require payment at the time of ordering, or they will not prepare and deliver the packet until they receive their money. We are back there now. So the POA and the condos have the right to say we are not going to give you that packet until you've paid us for it. That is, again, a change from where we've been for the past few years. The other change is that they have taken away the difference between a self-managed or volunteer-managed POA and a professionally managed POA. And so again, remember, there was a number of things that kind of changed about what was obligated, what obligations a volunteer or self-managed POA had. That doesn't exist anymore. If they're a POA, whether they're volunteer managed, self-managed, or professionally managed, they still have all the same obligations of delivery and packet information. All of these things for the resale packet do not take effect until contracts are ratified after July 1st. So if the contract was ratified prior to July 1st, we are the way that we have always been. We will treat that contract that way with disclosure packets and everything else until things that are ratified after July 1st, and then this list of things I just gave you kick in. The next thing is a couple years ago, recent years ago, the Bureau of Insurance released a letter that said, okay, we're going to enforce this 25-year-old law that says in split settlement situations, the seller can only be represented by an attorney. That has not changed. I already saw 2 questions on Facebook today about that. That is clearly not changed. The Bureau of Insurance has remained steadfast. The regulation that they have cited has not changed. You may only refer your seller side to an attorney or law firm if there's a split closing. Now, when all of that drama kind of dropped, there was some activity from your non-attorney settlement firms that were trying to charge inflated fees to the seller to perform the settlement because they wanted to make up their money. And of course, the attorneys on behalf of the seller were screaming and yelling, and they were all in conflict. And then we figured it out. Right? And that was predicted, right? If you go back and watch the video that I did about this whole mess, and in the follow-up videos we did to clarify the whole rest of the mess, I said, eventually the regulations or just common practices would sort itself out. The market would dictate that would not be an acceptable thing. And now, a couple years later, we decided to finally get around to the regulatory change. And I'd say that was a little bit of a snark there. But as of July 1st, the settlement company may not charge fees to the seller in a split settlement situation without consent of the seller's attorney. So in other words, they can't just throw something on the settlement statement and it be something the seller has to pay. They would need to submit their fees to the seller's attorney who's representing them, who would then approve on behalf of the seller the fees that they believe are reasonable and not duplicative and whatever parameters that they run. I really don't know the unintended consequences of that. That seems like at some point the attorney could just say, we're not paying any fees. And that may not be reasonable either. So that's their problem for now, not ours. The next thing that I think is important for you to put in the back of your mind, but you're probably not going to run into this very often, it's just a good relief to know it's there. We have had a problem in the past, even within probably the past year or so, with unreleased liens on property for entities that no longer exist, for creditors who no longer exist. So you're going to closing, you get a call from the settlement agent saying, hey, we've been trying to reach Circuit City Credit Card Company. I think somebody used that in an example, one of these updates I took, and I thought that was a perfect one. Your client racked up a bunch of credit card debt for an entity. They didn't pay it. The entity got a judgment, which would be required, meant to put a lien on the property for the credit card debt or whatever it is. Then we go to find out, well, we can't find that company anymore. So what the new regulation does is allow the settlement agent to take certain actions, and very specific parameters have to exist, in which they could still move forward filing and dismissing liens if the creditor no longer exists or can't reasonably be connected or contacted. So if you've got, some weird lien that somebody put in a house because of some roofing work that was done 20 years ago, the roofing company is dissolved, no one can find the company who put the lien out there. There's some things the settlement company can do to get it relieved, and fairly quickly. I think like one of the things is a 15-day certified letter saying we're trying to reach you for, get payoff and you're not giving it to us. So there's some things now they can do that should relieve a few problems we've had over the past few years with unreleased trusts. It's at least something to work with. So that's it. That's kind of the bulk of the regulatory changes this year. Again, as we go through training, contract trainings, forms changes, everything else, we'll start addressing some of these things in a more practical sense as they apply to our CE or contract class. So that's it. Thanks for watching the video here. If you have any questions, reach out to your broker, give me a call or an email. I'm happy to clear up anything that wasn't here. And I know there's a couple things that aren't resolved. We'll get that information to you as well. All right. Thanks for watching.